Well, good evening, ladies and gentlemen, and a very warm welcome to Fisher Hall. In a moment, I'll say a little bit about Fisher Hall, which is the academic building for the University of Notre Dame London Law Program. My name is Michael Addo, and I'm a professor at the University of Notre Dame Law School, but also the director of the London Law Program. This program has run since 1968. The London Law Program, generously endowed by the Concannon Foundation. Now, it's a program that has been accredited by the American Bar Association. As far as we know, the only one that has been accredited by the Bar Association for a year-long studies abroad. Over the years, we have had over 1,000 students who've come through this program. We have recently, under the leadership of our Dean, Marcus Cole, revamped and restructured the program under 3 broad concentrations aimed at taking advantage of the strength of the cities of London. We have focuses on international commercial tax and intellectual property, a concentration on international capital markets and corporate law, and public international law and international human rights law. Apart from the academic structure that we have, we also feel that we belong quite strongly in the community in terms of contributing to this host community by convening and organizing dialogue or opportunities to be able to exchange thoughts on pressing social issues. One of those pressing issues is the question of peace. That has eluded us, as you know, fairly difficult to attain. Of course, the question of peace is not just the absence of conflict, but also the finding ways of dealing with the subject other than through resolution of conflict. For us, therefore, we think peace can also be achieved through the rule of law. And for us, we have instituted this series of lectures to reflect on how the law may be used to achieve peace. Now, this Peace Through Law lecture is generously sponsored by an endowment from the Thomas F. Fay Foundation and the brainchild of a colleague of mine, Jimmy Gurule. Now, Jimmy was meant to be here to chair this event. Unfortunately, his flight from Chicago was canceled, and so was unable to make it. So we remember Jimmy on this day as part of his effort. Previous speakers on this subject have been, in 2022, Professor Theodore Marone, who was a professor at New York University and at Oxford University and a judge of International Criminal Court for Yugoslavia. Last year, we had Fatou Bensouda, the chief prosecutor, or the former chief prosecutor at the International Criminal Court. This year, we have our distinguished speaker that I shall introduce in a minute, whose biography is so long that if I mean to go through it, it might be the lecture itself. So I actually ask him to forgive me for the very short introduction that I will give, which doesn't do justice in any way to him. Having said that, I am delighted, and me personally, very honored. And I mean that literally. Anyone who in my position calls himself a human rights scholar or human rights advocate should be in awe of our speaker's presence. And that's what I am. That I am completely in awe of having him in our presence. Professor Juan Méndez, of course, for most of you know, is professor of human rights law at the Washington College of Law, a distinguished scholar, a very well-established, renowned advocate of human rights, a human rights administrator, and an award winner of many, many kinds. He, before, or in 2010, was the United Nations Special Rapporteur on Torture, Inhuman and Degrading Treatment. In 2004 to 2007, he was a special advisor to the UN Secretary General on the prevention of torture. And not just that, he's, as an advocate himself, has had being at the sharp end of, as a victim of torture, having been arrested and detained by the government of Argentina for advocating human rights. That didn't stop him. He served in 2000 and 2003, from 2000, as a member of the Inter-American Commission on Human Rights. He has also been an administrator of human rights because he served as the director of the Human Rights Program at the University of Notre Dame and has published over 100 academic publications and non-academic publications. He's the winner of a number of awards, which I dare say I cannot go through tonight. The annual Eclipse Award by the Center for Victims of Torture. He's had the Letellier Motive Human Rights Award by the Institute of Policy Studies. He's had the Louis B. Sohn, and for those of you who human rights know Louis B. Sohn's Human Rights Award by the United Nations Association. Is Patrick Rice Human Rights Award for Torture Abolition Survivors, Raphael Lemkin Award, Archway Institute of Peace, and the Gola T. Butcher Medal, the American Society of International Law Award. Now, as I said in the beginning, if I have to introduce him fully, that could take the whole evening. But I want to stop here and also indicate that tonight, Professor Juan Méndez will speak or deliver the Peace Through Law lecture with a focus on the prevention of mass atrocities. Without much ado, ladies and gentlemen, our speaker for tonight.
Thank you very much, Professor Addo, for those very kind words. I am very honored to be here today, bringing me very good memories of the 5 years I spent at Notre Dame in South Bend, Indiana, in the law school and with the Center for Human Rights, so Civil and Human Rights. And I regret very much that my friend, Professor Jimmy Gurule, who is to be blamed for this idea of inviting me to the annual Peace Through Law lecture, cannot be here because of these complications that we live in today's world, where you have to wait for hours in airports and then the flights are canceled. But I do want to express how much gratitude I feel at being here. And I was telling Professor Addo that I also had the privilege of being in this same building 20-some years ago, when we organized a very interesting conference on regional protection mechanisms. And one of the distinguished panelists that we had that day is the very well-remembered and regarded friend of all of ours, Sir Nigel Rodley. So for all of those reasons, it is an immense privilege for me to be here and to follow no less than in the steps of Theodore Meron and Fatou Bensouda, which you can tell gives me a little bit of jitters as I start my presentation. I wanted to focus on the duty to prevent mass atrocities because unfortunately it's still very much an urgent demand on our collective moral conscience to stop or to try to ameliorate at least the carnage, the mass violations against our fellow human beings around the world, especially the less powerful and the more vulnerable of us around the world today. Prevention is, I always think, a sort of a neglected area of human rights development, normative development, and of human rights practice. We seem over the years to have generated a lot of attention to how to respond to human rights violations when they happen. And so we have developed standards about the state's obligations. And more recently, we have developed standards about the international community stepping in when those duties of states are not respected, and to protect the torture victim, the disappearance victim, the victims of genocide. However, responding is important on its own right, but we have done relatively little to figure out how we could make sure that the violations don't happen in the first place, or at least that if there are threats that they are about to happen, that we have an appropriate response from civil society, from national and state institutions, but especially also from the international community, to make sure that they don't proliferate and commit the harms that we are unfortunately so familiar with. We have from international human rights law that is mostly based on state responsibility, there has been some progress in a response to mass atrocities that we sometimes call transitional justice, that basically reinforces the duty of states to the truth, to justice, to reparations, and to measures of non-repetition for those kinds of violations. All of which, but especially the latter, tend to have more a preventative effect than only a response to the tragedies that we have already suffered. In fact, in the normative framework that we apply, prevention gets a little bit of short shrift. The general human rights treaties, for example, the International Covenant on Civil and Political Rights, doesn't even prevent it, doesn't even mention prevention. However, in applying and doing authentic interpretation of the covenant, the Human Rights Committee and several regional courts have read into the obligations of the state the duty to prevent all the violations in the international covenant. There are specific human rights treaties that do mention prevention, at least in their title. And the most important of them, of course, is the Genocide Convention of 1948, that in fact is a convention to prevent and punish the crime of genocide. However, the convention text itself doesn't say much about how to prevent genocide. More recent treaties, like the Convention Against Torture of 1985 and the more recent Convention on Disappearances, are a little more specific about some aspects of prevention that are explicitly stated as obligations of states that sign and ratify those respective multilateral treaties. However, even there, the obligation, the duty to prevent is left to wide areas of interpretation and application in practice that obviously could not be contemplated in the treaty language. What is important, however, to insist on is that measures of prevention have to be carefully tailored to the violation itself, to the dynamic nature of the violations that happen over time, and to different stages and moments in which those measures can be more effective. And obviously, because there's no one-size-fits-all measure of prevention for genocide, for torture, for disappearances, and for crimes against humanity, which makes the matter all the more complex, but also gives us a chance to look at what we have done, more importantly, at what we have not done, and importantly also for why what we have attempted and done has not been enough to prevent some of the worst tragedies that we have seen in the last 3 decades. The measures of prevention have to be directed mostly still to the national jurisdiction, to the domestic obligations of states. And that's why state responsibility for human rights violations remain the field in which we try to create and then enforce responsibilities of the state in the matter of prevention. But they also have to be directed to the international community and to the political organs of the international community, because, as we will see, the Charter of the United Nations does assign certain tasks to organs like the Security Council that unfortunately are not effectively applied in today's composition of the international community. But it's important to remember that we are talking about a certain category of human rights violations to which we apply all these principles. Obviously, by reference to the Statute of Rome, we can say that the crimes under the substantive jurisdiction of the International Criminal Court is good guidance. Genocide, war crimes, and crimes against humanity, in addition to the crime of aggression. But I prefer to insist on a slightly broader category that we call international crimes, because there are certain human rights crimes that elicit the concern of the international community, not only to pay attention to them, but also to prevent them. And by that I mean, for example, the crime of torture and the crime of disappearances that are not part of the subject matter jurisdiction of the International Criminal Court, unless they're also part of a widespread or systematic attack on the civilian population. But torture and disappearances practiced even as isolated events, nevertheless are considered international crimes that the international community has pledged over and over to try to eradicate. And because they're international crimes, we have to insist on some of the norms that apply to how states are supposed to prevent these from happening in the first place. In the matter of genocide and crimes against humanity and war crimes, we have been hindered by sometimes not well understood rules on the prohibition on the use of force, and particularly on respect for the principle of non-interference with the domestic affairs of states. This issue of sovereignty has sometimes been the reason why the international community has been slow to protect people from genocide, war crimes, and crimes against humanity. But I want to insist, however, that use of force in international relations is well regulated in the Charter of the United Nations, and does put in the Security Council particularly the responsibility to react and to prevent mass atrocities as they happen. Unfortunately, that responsibility has not been observed in concrete action more often than not. Maybe there are cases in which the prevention of genocide has worked, and we don't remember it because we also always remember those cases in which prevention did not work. But both when it didn't work and when it worked, we need to draw lessons from it and try to do better. And in the 90s, particularly, these debates about the responsibilities of Security Council and also of coalitions of the willing, as they say in the United Nations. That is, a number of states acting independently and outside the channels of the Charter gave rise to debates about humanitarian intervention, and then more recently to the doctrine of responsibility to protect that was adopted in 2005 at the World Summit outcome that tried to reform the United Nations with little progress, but at least in this area established a doctrine for the United Nations to apply, particularly the Secretariat to be able to apply. And that was the reason for the creation of the Office of the Special Advisor on the Prevention of Genocide that was created in 2004 when Kofi Annan followed the lead of the Security Council in a resolution of 2001 in which the Security Council asked the Secretary General to bring to the attention of the Security Council matters and situations that, if left unattended, could derive into genocide or mass atrocities. And that office, started slow and with few resources, but now it's a pretty well-established arm of the Secretariat in the United Nations. And I think it has achieved at least one of its purposes, which is to make sure that prevention of genocide is a day-to-day responsibility that all different units of the Secretariat have in mind on a daily basis when they go to work. Of course, that's not enough, and painfully, the crises that we see today in the world show that that's not enough. But at least we have developed a certain way of learning lessons, and I would say that we should draw those lessons from first the International Court of Justice decision in Bosnia and Herzegovina versus Serbia, in which, although some of its decisions were more controversial than others, but it did establish one principle that is important. First, that all nations in the world have the duty to prevent genocide wherever it happens. But those that have the most direct ability to influence the situation have a heightened responsibility to prevent. And in this particular case, the court did find that Serbia had not lived up to its responsibility to prevent, even though it did not say that Serbia itself had committed genocide. It did say that it had more responsibility for proximity, for cultural history, for the history of the recent conflict, and for cultural relations, more responsibility to intervene to prevent the genocide that happened in Srebrenica. That, I think, is a very good guidance to us, and especially it's a good guidance to insist that powerful nations that have the ability to influence situations around the world also have to have a heightened responsibility to prevent genocide wherever it happens, especially if it's a situation in which allies may be complicit or even perpetrators of mass atrocities. But in the meantime, however, we've also learned some other lessons of practical measures of prevention, and mostly based on my experience as a special advisor to Kofi Annan on this area in Darfur. And unfortunately, everything we did 20 years ago seems to be happening again today, which is really tragic. But what we what I think can be learned from those failures, maybe partial successes, but also overall failures, is that we need to act on 4 fronts at the same time. And the 4 fronts are: 1, protection of people who are at risk of genocide or other mass atrocities, just standing in front of them so that they will be protected by military means if necessary, by civilian means and law enforcement means if possible. But we need first and foremost to protect. The second one is humanitarian assistance that has to happen at the same time, because people who are vulnerable are also victimized already by the fact that they have been displaced, that they're not able to get food in the table for their children, that they have to live in tents for literally decades. So humanitarian assistance is an important area that we need to work on. And especially because the way that humanitarian assistance is delivered in today's world is very effective and very quick, and it also puts a lot of well-intended civilians in close to the area where the violations are going to happen and are witnesses to what can happen and can give the warning more effectively because they are there. The third one is accountability, because by and large, by the time the international community has something to do about this, very serious violations have already been committed. And the impunity for those violations is a factor in the instability and the inability to protect people. And it's also a factor in not letting the victimized group and the vulnerable groups be able to exercise some autonomy. Because if they know that the people who victimized them only a few weeks ago are still around and ready to victimize them again, that is also another source of instability and of repetition of the violations. And the fourth area that I think we need to focus on is peace negotiations, because there's always an underlying conflict, and there's always, sometimes they are long-standing, but it's very important to get to the roots of conflict and to try to settle differences in peaceful ways. And you can't wait until the situation is more or less stable to enter into long-term peace, conflict resolution matters. But at the same time, those 4 areas have to be attended to with a view to the dynamic nature of the situation. So what we say, for example, on humanitarian assistance today may need to be supplemented with something else that we say a month or 2 from now as a situation of humanitarian assistance changes. And the same for all 4 areas, I mean. And it's very important, therefore, to provide early warning and suggestions for early action, but they also have to be tailored to the sometimes very rapidly changing situation on the ground, and make sure that they are effective in their own terms of what is happening there on the ground. I would say on the question of prevention of genocide that I'm still concerned at what I observed when I was a special advisor to Kofi Annan on this matter, and that is that we have this reluctance to use the word genocide, lest we have to do something about it. And it seems to me that we are overly concerned with meeting the exact definition of genocide, when in fact what we need to do is prevent it. So if we're going to prevent it, we cannot wait until every element is there, because by then we haven't prevented it. So we have to focus on the risk of genocide with the possible, deterioration of the situation into something that can be qualified as genocide. And if we put the emphasis on the risk, I think it is also important to name it by its name. We're talking about the risk of genocide in places like Ukraine today, in Gaza, by just saying that genocide is off the table is a way of not being effective in trying to influence the actors on the ground so that genocide doesn't happen. And if genocide doesn't happen, but we still prevented crimes against humanity and war crimes, we've done an important service to humanity. And I would also want to move on to prevention of torture, which is something that I've been working on more recently. And as Professor Addo mentioned, I mean, there is this clear sense in international law that torture is absolutely prohibited. There's no justification, no emergency situation that even tolerates it. And this is a jus cogens norm. That is an imperative norm of international law that even states that don't sign and ratify the Torture Convention are bound by it as well. However, all of those nice things about the law applicable to torture is not enough to eradicate it. And that's why we need to move into the preventive area. And in terms of standard setting, the international community has not been idle on this, because in the normative framework that applies to torture, we have from the 1950s, the standard minimum rules on the treatment of prisoners that has always been considered, yes, a soft law instrument, not a non-binding instrument, but a very highly weighted means of applying in practice the absolute prohibition on torture and on any other kind of mistreatment, cruel, inhuman, and degrading treatment or punishment. And besides that, we have some of these instruments have been evolving over time. And since 2015, the standard minimum rules have changed its name to the Nelson Mandela rules, and now incorporate norms about limitation of solitary confinement to make sure that it doesn't last more than 15 days, and that is never applied even for hours to certain categories of people deprived of liberty, like children, like persons suffering from any kind of mental disability, and pregnant women and breastfeeding women. So we have those standards now, and it's going to be a slow process, but some states are moving in the direction of adopting them in their own domestic legislation and regulation. We need to do, of course, a whole lot more, but the fact that there is a widely agreed upon standard is also an important aid in litigation on prison conditions, for example. And many lawyers who practice in this area are using these standards effectively. Of course, the optional protocol to the Convention Against Torture is a treaty and creates a treaty body, the Subcommittee on the Prevention of Torture, that aims to prevent torture by conducting regular, periodic, and even unannounced visits to places of detention. And it follows on the steps of the Committee on the Prevention of Torture of the Council of Europe, that has a long history of doing this and doing it very effectively and influencing policy in many countries, members of the Council of Europe, to make detention centers more humane and more compliant with international law standards. I also want to mention the Istanbul Protocol from 1999, but recently amended, and now it's called Istanbul Protocol 2022, because it incorporates a lot of practices from the way the torture can be documented and proved in court through medical science and psychological and psychiatric science. The protocol has been updated, as I said, with recent advances in science, but also with the practice, and particularly the practice of how difficult it has been to make states require their forensic specialists to apply the protocol in all its ways. And then I also want to mention one non-binding instrument that is very dear to me, because I proposed to create it in my very last report to the General Assembly when I was a special rapporteur on torture. And it elicited a lot of interest, and 4 or 5 years of work. Took a little longer because of the pandemic. But in 2021, we issued this document that's called the Principles on Effective Interviewing in Investigations on Other Information Gathering. It's a mouthful and difficult to remember. I had to practice in order to be able to say the whole title that way. But importantly, it has been adopted in 2 General Assembly resolutions already, 1 General Assembly of the Organization of American States also adopting it, and it has been adopted in a couple of domestic jurisdictions, in Colombia and in Brazil, and it has been generally well received by academics and practitioners. The academics coming from various fields like criminologists, psychologists, neurologists, and of course, lawyers. And I think the importance of these principles is that it's just the bare essentials of what a protocol on how to interview people in criminal investigations should be done. And it's not should be done only in the sense of respecting international human rights norms, especially the presumption of innocence, and of course, the prohibition on torture and any form of coercion, but it's also and it's proving to be a much more effective way of serving the objective of the investigative interview, which is not getting a confession. It is getting to the truth of what the system wants to find out. And there's ample evidence that a methodology that serves the purpose of human rights is also more effective in fighting crime. And that's why I think we're going in the direction of being adopted in various international, national jurisdictions, I mean. In the matter of disappearances, I also want to mention that we have from the 1990s, a convention in the Organization of American States against enforced disappearances. And in the 2000s, we have one in the United Nations as well. And they have some very specific areas of prevention of disappearances. For example, the obligation to maintain an accurate registry of every person deprived of liberty, by whose order and where, and particularly avoiding the use of clandestine centers of detention, where mostly torture mostly happens. This registry of detentions should be the way to avoid the use of black sites and extraordinary renditions, as we saw, unfortunately, during the so-called global war on terror, which, to the discredit of many Western nations, the threat of international terrorism moved some states to, kind of soften the prohibitions on torture, and by calling these things enhanced interrogation techniques rather than torture, we actually had disappearances of a short, not short, but temporary disappearances, not ending necessarily in the murder and the hiding of the body, as in most other cases of disappearances, but still disappearances that promoted and facilitated the exercise of very severe torture. So the conventions on disappearances also insist on access by the person deprived of liberty to family, to lawyers, and to doctors, so that not only their fate and whereabouts is established from the start, but also the conditions of detention and the way they're being asked to cooperate with investigations can be monitored. And of course, insisting on courts and prosecutors and public defenders giving good use to the writ of habeas corpus and other forms of establishing the legality of a deprivation of liberty is an important preventive mechanism that we should use much more frequently. I think obviously there are other ways to talk about prevention of other crimes, but I insisted on these three: genocide, torture, and disappearances, among other things because I spent a lot of time working on them. But I think the prevention in all of this have some common threads. And the one that I would want to insist on is the need to break the cycle of impunity for these crimes. And we need to uphold what we call a right to justice. The right to justice takes different forms, and it's access to courts and this and that, but the access to justice of someone who has just been deprived of liberty has to take the form of, the mobilization of the courts and of the institutions of the state rapidly to establish fate and whereabouts and conditions of detention, and particularly to prohibit the use of coercion. And of course, this applies in even more important ways to breaking the cycle of impunity for the situations that are deteriorating into genocide or other mass atrocities. Of course, we apply this to certain categories of crimes. I mentioned already the Rome Statute that gives us guidance, but international crimes add torture and disappearances even when they're not part of a widespread or systematic attack on the civilian population. And I think the international community is moving in the direction of adding some other human rights violations to what we call international crimes. For example, trafficking in persons, transnational terrorism, and even some forms of transnational organized crime are eliciting the concern of the international community, mostly by means of multilateral treaties of mutual judicial assistance. But they should be incorporated into this form of looking at prevention that I'm talking about. We do have case law standards that go in the direction of what I'm saying. And so, for example, many decisions by international courts, especially applying state responsibility, establish that there is no room for amnesties for these kind of crimes, no room for other forms of keeping those crimes unaccountable, like statutes of limitation, for example, or prosecutorial discretion not to prosecute. In the Americas, we have a long line of cases. I just want to mention Velázquez Rodriguez versus Honduras, that is about disappearances, but also Barrios Altos versus Peru, about amnesty laws, and Almonacida Arellano versus Chile, that is about mechanisms, a little more subtle than amnesty laws, but mechanisms that for procedural or jurisdictional grounds don't allow the exercise of the right to see justice done in cases of human rights violations. But it's not only the inter-American system. The European Court of Human Rights has consistently insisted on the obligation to investigate, prosecute, and punish even crimes committed during the Nazi era or the Soviet Stalinist era. So, and the most important one that I want to mention is more recent, is from 2012, I believe, Margus versus Croatia, where the court said that when it comes to these kind of crimes, the exercise of prosecutorial discretion not to investigate and not to prosecute is contrary to the European Convention on Human Rights. Of course, we need to strengthen the international backup to these state obligations. And there we have some good case law from the ICTY in Furunzilla, from the ICTR in Acayesu and the Radio Milcolin cases about rape and sexual violations as genocide. And those cases give us a lot of arguments for going forward in the area of prevention. And let me just try to wrap this up by saying that to be effective, prevention, as I said, requires different means and measures by different and various international actors. And we need to agree to use dynamic responses to the different ways in which these very volatile situations deteriorate or can actually be made to improve. But the ultimate bottleneck is lack of political will, and I'm sure I don't need to persuade you of that when we bear in mind what happened in Rwanda, what happened in Srebrenica, what may have happened in several other places in the former Yugoslavia, although Srebrenica is the only one in which the ICTY called it genocide. What happened in Somalia after the famine, and you know the fact that the international forces left the place before the job was completed, and of course Darfur that I mentioned before. So prevention measures should be designed to attend to the immediate situation, but also to build the political will that is never there to begin with. There's always the need to insist on states living up to legal obligations, and if not, at least to moral obligations. And we, the citizens of the world, need to be part of this pressure to get the states and the international organs of the international community to make sure that they do live up to their obligations. So we insist on certain measures that on their own may not be immediately effective, but that build this political will that needs to be created every time. Unfortunately, it's never there to start with. For that, therefore, we also need to involve civil society. Mostly because the civil society organizations are the ones that are closest to the victims or the targeted population for these mass atrocities. And also because they carry this moral obligation that I've been talking about, sometimes more effectively than states do. And finally, we need to be ready to act, but we need to be ready to act also with the directive not to make matters worse. And that's why I think it's a very difficult balance sometimes to see what measure exactly is going to do the trick, and what measures that no matter how well intended may even not only not be effective to stop the carnage, but can actually worsen the situation. But that's the conundrum of all moral obligation. Doing the right thing, but doing it not for our own moral satisfaction, but also bearing in mind all these conditions in which the moral obligation to do the right thing is also the effective one. Well, thank you very much. I think so.
Very much, Sir Méndez, for quite an enlightening and at the same time challenging, calling on everybody to do their little bit. Thank you also for kind of setting out what I see as your 4 pillars for prevention, the question of protection, question of humanitarian intervention, question of accountability and peace settlement. So we have a little clear roadmap. But you also mentioned some of the challenges. Your final comment on political will. But you also earlier on mentioned basic legal norms of sovereignty, another of those pillars. So we do have challenges. Now, Professor Méndez has very kindly agreed to take questions and answer some questions. Before I go off to the floor, maybe I shall abuse the chair's position to pose a little question just to get it thinking. Thank you again for this, but the large focus of prevention that you've given us, largely lying heavily on states and international institutions. But then I reflect on Rwanda. You mentioned Radio Mille Collines, for example. And then I reflect on disappearances. I reflect on instances of torture. Most of these mass atrocities seem to be driven by some private actors. Now, where would your 4 pillars of prevention be if the focus really should be on private actors? And I'm thinking wherever there is mass atrocity, there is use of arms, for example. And that's what is used to cause it. And that's through some private actor sales and some commercial process. Will you adjust your 4 pillars of prevention a little bit, or would you add an extra pillar when it comes to private actors, or can we adjust them to deal with private actors?
Well, certainly private actors are in some conflicts the main forces that commit the atrocities. But in many others, for example, in international conflicts, there's no question about the perpetrators being state actors because they are part of the forces that are fighting each other. And even when it's private actors like organized crime or like rebel forces that commit atrocities, there are some responsibilities that we can insist that states live up to. And as the doctrine of responsibility to protect well establishes, there is a sort of degree of responsibilities that have to be met. And so first and foremost, the responsibility to protect people from mass atrocities, whether committed by state actors or non-state actors, lies with the state. And only when the state is unable to protect the international community then has to come to the assistance of the state if the state is willing but unable. And only in the third stage, when the state is unwilling or or unable, or rather it is the main actor committing the atrocities, the responsibility shifts to the international community to protect those people, and this applies, for example, in the case of the International Criminal Court, to the principle of complementarity. I mean, the ICC doesn't have jurisdiction if the state is doing what it is supposed to do. But I think it also extends to all of these levels of violations that I mentioned. Obviously, when we talk about prevention of torture and prevention of disappearances, the emphasis is on what the states have to do. But if the states don't do it because they can't, then we all have the common responsibility to help the state fulfill its obligations. And thirdly, when it's a state that is the obstacle, then the international community has the responsibility, certainly through the legal organs of the international community, particularly the Security Council, not running rogue over the whole architecture of the international community, but living up to the obligations. And particularly, I mean, obviously the problem here is the composition itself of the Security Council, because the veto powers that five of the members, the permanent members, have, becomes a check into the ability of the Security Council to provide good ways of preventing mass atrocities. But it doesn't mean that we cannot insist, and the citizens of the world have to insist that veto or no veto, the Security Council has to live up to its obligations. And it has to negotiate thoroughly, but not let the vetoes erase the possibility of the international community responding appropriately.
Thank you. Please.
Sure. Hi there. Thank you so much for your talk tonight, Professor. It was really interesting. I'm Max Gucci. I've just graduated from the LSE. And my academic background isn't exactly in this, but similarly connected with development economics and that sort of thing. So my question is really to the heart of what you're talking about when it comes to breaking the cycle of impunity, and then particularly political will to break that cycle of impunity, particularly when it comes to mass atrocities, but also torture and all that sort of thing as well. So when it comes to political will, I think, at least from my experience, we're in a time of really low political will, and if anything, decreasing political will, not just from each of us and citizens of countries around the world. We see in the United States at the moment, really that pull away from international affairs through kind of the voting that's been shown to have occurred. Citizens themselves aren't interested in kind of getting involved in international affairs, and then also the fragmenting world order on top of that. Again, the United States not in the dominant position in the world that it once was, and then even countries like Britain, threats to draw out from the ECHR, from the Conservative Party, and all these sorts of things, the rise of the BRICS, China, India, and it seems to me as if we are actually facing a crisis of political will and a decreasing ability to break this cycle of impunity. So where do you see the effect of these factors on the prevention of mass atrocities and torture and the like?
Yeah, well, I hope I was nuanced enough to take into account that affording absolute right to justice to victims is not always available. It's not, and sometimes it's not even the proper course of action, because if you tell a rebel force, for example, that we're engaged in these peace negotiations, but once you sign, you go straight to jail, that's not a very productive way of getting people to sign a peace process. So on the opposite end, I don't think it's a good idea either to offer complete impunity in exchange for signing in the dotted line, because experience shows that the conflict goes on and people violate their own promises, and there's more violations. And even if that were not the case, it is it would be a denial of justice to the victims to say, well, in the interest of peace, you have to forget about what happened to your daughter, what happened to your husband. We decide that you have to forget. And so, but I do think that transitional justice, the way we've studied it happening in different parts of the world, gives us a sense of, what to insist at different moments, what to insist on at different moments. So, for example, those of us who come at this from the human rights perspective should never be allowed to be put in the position of the spoilers. We object to any resolution of the conflict because we want justice done. And in the meantime, if the fight goes on, we are being responsible also for the new deaths, the new torture, the new disappearances. So we have to have the sense that the peace process should not eliminate the possibility of justice for the victims, or they eliminate the possibility of truth-telling for the victims. So we should see the conflict resolution mechanism also as a dynamic process whereby you can get some things done now without canceling the possibility of justice down the road or truth-telling. And when we talk about justice, we don't necessarily mean that every single incident of torture, for example, should be prosecuted and punished, including all that played any kind of role in the torture. In the real world, that's not the way it's going to happen anyway. So making the false promise that we will get that done also is not very conducive to any of the other needs to build the political will that gets us where we want to go. So we can always think about opening roads towards justice in different ways. And I think truth-telling is one of them. But truth-telling conditioned on absence of punishment is probably unacceptable to the victims. And if it is unacceptable to the victims, it should be unacceptable to us as well. I'm not sure that I addressed what you were looking for, but.
It was a super interesting answer. If I could just quickly just ask a follow-up question on what you said there about truth-telling without justice potentially not being satisfactory to the victims. I think some really interesting examples of actually that happening potentially are, for example, post-apartheid in South Africa, the Truth and Reconciliation Commission. I think that was a really interesting example of truth-telling without punishment for the perpetrators of the crimes of apartheid as actually being potentially a really helpful way of moving on from those sort of mass atrocities and those problems. So it's kind of interesting that maybe in some cases there are instances of truth-telling being a good path to moving forwards, even if not providing justice for the victims.
Yeah, well, I mean, in the 90s, there was a big debate among transitional justice practitioners about whether to prioritize truth over justice. In fact, there was an edited book that was called like that, Truth versus Justice. And I was among the ones who said, how can we, create a conflict between two important values like this? I mean, what I meant by this is that the victims have a right both to the truth and to justice, and to reparations, and to measures of non-repetition. How to achieve one or the other simultaneously, it's almost impossible. So I would be very much in favor of a big effort to establish the truth of what happened, as was done in South Africa, in an exemplary way, I would add. But not at the expense of making people say, forget about justice. But I want to stress that I don't see the process in South Africa as doing that. In fact, the process, during the whole Truth Commission work, the process of investigation and punishment of some of the atrocities was still very much there. And the amnesty was conditioned on coming forward and saying everything you know. It didn't really work very well, but you cannot say that it was truth against justice. And maybe even today it's still possible to do justice to at least some of the episodes. And I'm gratified, for example, that the killers of Steve Biko did not get amnesty because they appeared before the Truth Commission panel, and they could not show that their crime fell under the criteria for granting amnesty that was part of the Truth and Reconciliation Act. And we can mention cases like that in other countries as well, but thanks for bringing up South Africa.
Right. Can we take some more questions?
Well, just a quick question. Is Islam compatible with international peace?
Well, I'm no expert on Islam, and no expert on religions in principle either. But I think well understood, all beliefs that are based on some form of relationship with the world and with the Creator are in principle compatible. I mean, there are examples of deviations of that compatibility, and certainly some extreme forms of terrorism that is based, supposedly based on some interpretation of Islam is, of course, incompatible. But quite frankly, we've had over centuries of history similar crimes committed by us in the name of Christianity. So I think we should be judgmental of the acts itself, but not of their supposed justifications.
Yeah, I'm slightly concerned that you say you're not an expert on Islam. I don't expect you to be an expert, but certainly to have a working knowledge. I mean, Islam is you mentioned Darfur, you mentioned Herzegovina, whatever it was. And of course, we've recently had October the 7th of last year, and it is a mass atrocity. So this thing, you know, other religions do it. I think Christianity, and that's often pointed to, there are violent things in Christianity, but they're in the Old Testament, they're superseded by the New Testament. And also it's local, there are tribes doing this and that and others. And it's being described as descriptive, whereas Islam is prescriptive. You know, there's certain things in the Quran, the verses, I mean, 533, the verse of the sword, which are violent.
Hello?
And
Hello.
they are for all time. So I just put that forward and leave it with you, okay?
Thank you. I was going to say, please, can we limit ourselves to questions, if we can? Yes.
Hi, thank you very much for your really insightful thoughts. So while it's unlikely that the formal criteria for genocide will be changed, certainly any time in the future, or in the near future, I was wondering whether you thought that there could be a shift in state practice and opinion juris towards, as you were mentioning, risks of genocide being considered as more of a consideration rather than being able to go in afterwards when you're unsure whether you can meet the criteria after the atrocity has already happened. Do you think that there could ever or is currently a shift in state practice towards expanding or broadening the criteria for genocide?
No, I don't think there is any serious move to expand the definition of genocide as existing in the Genocide Convention of 1948. And the travaux préparatoires of the convention is rich in the debates that led to genocide being considered only the 5 genocidal acts as perpetrated with a purpose of eliminating in whole or in part a community that is also signified by 4 criteria only. And that's race, religion, national origin, and ethnicity. Yeah. I don't think we need to change that because for better or for worse, I mean, some countries, and they have the right to go to expand the protections against genocide to other communities. For example, France, from the beginning, signed and ratified the Genocide Convention, but as a matter of domestic law in France, genocide also includes the same forms of persecution of people designated by ideology or political affiliation, which is not the case in most other countries. So we don't need to change that. What we need to do is make sure that we don't wait until all the elements of genocide, because it also includes the specific intent to destroy in whole or in part. And there's never going to be the smoking gun that says, I am the president and I want to eliminate all this or this big portion of our national community. But you can read genocidal intent from the facts on the ground. What I was saying about insisting on the risk of genocide is that if we're really intent on preventing it, we shouldn't wait to make sure that all the dots and all the commas and accents are in place, because if there is a risk of genocide, that should be enough for the international community to act. And if it doesn't get to genocide, all the better. But we shouldn't be avoiding the word, for example, or saying, well, you know, it's wrong, for example, for South Africa to go to the International Court of Justice alleging the possibility of genocide in Gaza. I mean, if it doesn't happen, then we can criticize South Africa for jumping the gun. But in the meantime, there are people dying, and the risk is there, and that's what should trigger our concern.
Right. Can I just say that just behind us, well-laid tables that kind of suggest that we need refreshments, and I'm quite conscious that that's just as important as the legend. So I'm going to suggest we take one last question. And then we have one more formality before the break through. Then one last question, if there is one. Anybody? Well, okay. In which case you keep it short.
Okay, as short as possible. Is torture ever justified? So I understand that we should work as much as possible to avoid torture. However, could you set up a scenario, if only as a thought experiment, although it may be realistic, where not only is torture justified, but it's in fact morally required? Are there situations that are possible like that?
No, the short answer is no, because the convention says it very clearly. There's no emergency situation that would justify the use of torture. But there is always the argument of the so-called ticking bomb scenario. And it's an argument that we have to take seriously, because people who use it are also living in very difficult situations and risks of terrorism, etc. But taking it seriously doesn't mean buying the argument. In fact, in 1999, the Supreme Court of Israel, in a case called GSS, I think it stands for the acronym of one of the intelligence services, that had asked for permission to conduct interrogations with 5 different techniques, etc. And the Supreme Court addressed the question of the ticking bomb scenario and said that it might mitigate the responsibility of the law enforcement officer that believes in good faith that they're doing a better, serving a higher purpose of saving lives by doing the lesser evil of committing torture. But it doesn't justify an administrative program, the Supreme Court said. You can't say, well, because maybe one of the people that we torture knows where a bomb is ticking, we should be able to torture everybody. And the ticking bomb scenario actually came, in almost exactly the factual version of it, which almost never happens, but it did happen in Germany, and the European Court of Human Rights basically found in favor of Germany in a case in which an officer had threatened, had not even tortured, but had threatened a kidnapper with torture unless he said where the child that he had kidnapped was, thinking at the time that he might save the life of a child, and in fact, he had already been killed. But when the case came to Strasbourg, with the culprit of the kidnapping and murder of the child saying, I was forced to confess, the court said Germany did what it had to do. Why? Because Germany did not condone the threat. They actually disciplined. I mean, of course, it was a very mild disciplinary gesture, but it did discipline the person who used threat, even guided by a moral instinct that he thought was doing the right thing. So, you know, as I said, it's almost impossible to see those things happening in that way, but at least we have some guidance from the law and from morality, I think, about what we can do about situations that are so extreme that lead the rest of us to say, well, maybe in that case, torture is enough. I have to say that it's the popular culture that conditions us to think that way. You know, you can see television shows and movies where you find yourself siding with the law enforcement officer who breaks the rules because he's a sympathetic guy. And unfortunately, that is one of the reasons why it's so hard to eliminate torture from our lives. Sorry, the longer answer.
1 minute. I almost thought if you bring upon torture, he will give you a lecture that lasts. But thank you very much. So Méndez, on behalf of Dean Coe of the Notre Dame Law School and on behalf of our distinguished audience, I want to thank you for a very, very enlightening lecture. I must say, one of the things that I take from this lecture is this idea that we all have individual responsibilities to prevent torture. And that occurs to me while we were preparing for this lecture, but way before we even nominated him to be the lecturer. That, I mean, we recognize the kind of work that he's done over the years, both as an academic, as an advocate, as a special rapporteur, as an advisor to the Secretary General, as an administrator, pretty much devoting your entire life to what you are preaching, which of course tells us that we could all emulate some of the things you do. And in recognition for what you have done over the years, the least we could do is to try and get others to emulate you by actually nominating you for what we have in Notre Dame as the Peace Through Law, for all the work that you've done through your laws as a teacher, as an advocate, to achieve peace. And the Dean and the faculty actually have decided to endorse you as the 2024 award winner of the Peace Through Law Award. The citation here, on a much longer citation, which I cannot read here, says this is for your lifelong selfless dedication to the defense of human rights and a commitment to the rule of law and global pursuit of justice. So Méndez, I'm delighted to award you the prize, Peace Through Law. Thank you.
I'm not going to go on lecturing, but I want to say that it's very rewarding for me to get this from Notre Dame. But also, you know, I've been very fortunate to be able to live and work on human rights all my life. And it's been a series of fortunate events that led me, and some unfortunate, but some fortunate events that led me to it. And, you know, getting an award for it at the same time is overdoing it a little bit, I think. But thanks very much again.
Thank you. Ladies and gentlemen, this concludes the very formal part of this. So Méndez will still be around, also needing some refreshment. So please feel free. For those kind of questions that you're not prepared to put in public, please ask him in private. I'm sure he will be prepared to.
Yeah.
And if I find that he's a little bit in being harassed, I will rescue him.
Oh, right. Yes.
Thank you very much.
Okay.
All right. Was it
Should we
too
take
quick?
it out?
You missed it?
I got it. I just wanted to make one.
Right, okay. Thank you. All right. Now, how are you?
Thank you very much indeed.
Thank you,
for
Father.
all you've done and for what you're still prompting us to do. I did have a thought about what happens when a state expels the United Nations from, I'm thinking obviously of recent things in Israel. The expulsion of the United Nations.
Yeah. Well,
Maybe want to turn your microphone off.
Yeah, good call.
no,